So our guest today is On Lee Sue. He's running for the 360th District Court against Judge Baca Bennett. And the March 5th primaries are coming up, folks. So we hope you'll, be voting. This is for the Republican primary specifically. But On Lee, thanks for being on our little podcast here. We really appreciate it. It's actually quite an honor to have a family court judge candidate come on. Tell us about yourself and why you're running for family court judge.
Oh wow! So I've probably shared this story more than
Oh,
I ever have, but I'll do it again. So again, my name is Lee Shu, and I'm running for the 360th Family District Court. Um, a little bit about myself. I think that when we look at the values of what we look at in a judge and the conservative values of family, um, we want to look at what they're about and kind of the background they come from. And I always tell people a little bit about my background because I think it's very crucial for people to
mhm.
understand where my morals come from, where my values come from. And so I always start by telling people, look, I understand the tenets of freedom and liberty, and I understand the tenets of family, God, family, and country. And the reason why I understand that is because I, even from a small age, I was told the story about my grandfather. He was a 27-year POW in communist China. Uh, Now, a lot of people go, well, what was he there for? And I'm like, that's why I use the word prisoner of war, because um, what occurred is in 1948 when Mao took over and the communists took over, um, he was a military member in China ROC, not to be confused with PRC. And what he did is he took my father's side of the family, my grandmother and everybody like that, and a part of the Chiang Kai-shek movement moved them to Taiwan. And but rather than stay there like so many other people did, he chose to go back and fight. And we know, of course, history in hindsight is 2020. There was no actual war, and as a result, when he landed back at his base, he was captured and then subsequently submitted to prison camp, and then was sentenced to the first 5 years of hard labor, and then the remaining 22 years he served in a re-education camp um, in communist China, and they subjected him to all sorts of forms of mistreatment, torture, etc. And it wasn't until about 77 that he was actually released. And the interesting thing about that is he wasn't released to Taiwan because Taiwan, the place that he took my parents, uh, didn't want it. They didn't believe that they wanted to take in political distance from China. Um, and as a result, even though he was firmly part of the Chiang Kai-shek movement, he believed in the Republic. My family has been Christian. They're in, you know, and they've also been conservative their entire life, but they believed in every tenet of the original government, and not even Taiwan would want. And so, as a result, thanks to a church here in Arlington, Texas, called First Christian Church off of Park Row, they gave my family a house that's essentially front of the property of the church, and
Mhm.
um, and they processed his asylum and supported his asylum to come to the United States. And that's how he ended up here in the United States in
Mhm.
77. The sad part is he lived a very poor quality of life since he was got here, largely due to his health. But
Mhm.
thankfully to the church, he was able to basically live out the remainder of his life in relative comfort. They would give him a job as a janitor because he didn't speak any English
Mhm.
at the church. And then in addition to that, they gave me free daycare. I was a wee little kid at the time, and they gave a house in the front of the church to allow my grandmother and my grandfather to live in. And so we owe them an
Mhm.
immense amount of gratitude to that church, and we owe the United States an immense amount of gratitude for taking on these programs to bring in, POWs from communist China. So that's where my grandfather came from. My father and my mother immigrated here a few years before my grandfather was released into the U.S. custody, and they are the embodiment of the American dream. They truly are. Um, they came here, and I was. My mother told me the story 1,000 times. They came into the United States with $63 in hand. Now, adjusting for inflation, which we've had a lot in the previous few years,
Mhm.
that's still not a whole lot of money. And then so my father and my mother don't have anything greater than a high school education, but they both worked extremely hard, and somehow they managed to raise myself, who ultimately became an attorney, and then my sister, who is a doctor in physical therapy.
Hmm.
So I'm extremely proud for them because I'm a product of their hard work. And
Yeah.
I don't think you can say any other country that a firstborn uh, American from an immigrant
Hmm.
family can run for office, number one, and number two, really fully grasp the concept of being privileged to be able to serve in public service. And so I look at that. Now, I can tell you, like, my politics involvement has been relatively smaller than the majority of the candidates. But the reason being is I started politics. We've always assisted with candidates in the past. Judge Alex Kim was one of the first judicial candidates that we assisted. Judge Christopher Taylor was another one that we assisted and helped in their campaign. I was kind of brought into the world of politics by my precinct chair, so I have an immense amount of respect for them too, because my precinct chair, Sheridan King, at the time was the one that kind of got me in touch and taught me the ins and outs, doing the block walking, how the party works, how things kind of go in and out. And then over the time, I got to know Alex Kim really well, and him and I became friends because we have a lot of the same hobbies. So, um, there's a lot of that. But a lot of people always ask why I have not been more involved in the party. And, I go back to my family. To be
Yeah.
honest with you, when we look at politics, my family, by every definition of the phrase, was religiously and politically persecuted. And so
Mm.
we've always been taught the tenets of hard work and perseverance. And that's how I've always carried my life. I believe in excelling in everything I do, yet having humility, doing well in anything that I do, yet being humble. And that's the reason why I've always looked at politics. And I said, we've kind of shied away from that because putting yourself in the light is somewhat the opposite of being humble. You don't want to throw yourself out there because in a lot of politics we talk about I, and not so
Hmm.
much about what we come from and why we are who we are. So the last thing I'll say is with issues
Yeah.
of the court,
Hmm.
I'm running for this court because I've seen a progression in the court over the course of the last 10 years of my practice, and it's a scary progression. We've seen um, an absent-mindedness, if you will, and then a disregard, an active disregard of certain policies and certain laws. We've also seen an amount of favoritism go to repeating litigants, and we've also seen a certain increase in what we call uh, bad judicial outbursts. Judicial temperament is one of those most important things I
Hmm.
see. And the culmination of this is we get inconsistent rulings, we get bad law that comes down from it, and then worst of all, we have litigants that feel like they never get their day in court, despite spending tons of money, despite spending tons of time and subjecting their families through an immense amount of litigation to really not ever get heard in their day in court. And I think that's a problem. Um, I personally witnessed these type of things, and I think judicial temperament and self-awareness are two of the most important, if not the most important, uh, characteristics of a judge, because in this instance, temperament is exactly what you need, the ability to be able to stay calm and not
Hmm.
inject more emotion into an already extremely emotional situation. And then with respect to self-awareness, because we're all human, um, there's a some time in emotional situations, judges may make a rash decision, but that self-awareness, that second guessing yourself, that's not weakness. I was once told by a judge that's sitting on the bench right now, I don't want to say him out loud, but he told me, I asked him, I was like, man, I second guess myself a whole lot. He said to me, he goes, Ann Lee, if you ever stop second guessing yourself and the decisions you make on a daily basis that affect other people's lives, then you probably shouldn't be on the bench because you need to understand everything about what you do and you need to question those things and make sure your decision, but you need to understand that decision, and self-reflection or self-awareness is how you do that. So that's why I looked at this court. I was I had the chance to run against some other judges, and I picked this court because I felt that this court needed the most amount of help. I have a different vision for this court.
Okay. And I want to dig into some of those topics, but let's let you just, however you want to phrase it, talk about the differences between you and Baca Bennett. We can talk about her history. She does have a certain perception with her temperament. I've heard an attorney say that she goes from 0 to 100 in a second, which gets back to this idea of like, if I'm a parent in that courtroom and I see the judge just lose his or her temper, that's not only frightening. I begin to question their ability to make impartial rulings. But go ahead and talk about the differences between you and Judge Bennett.
So again, I go back to the whole self-awareness and temperament concepts. You had mentioned earlier that she has a reputation for that, and that's among the I don't ever want to detract from the parties that appear before her, but there are several issues that we've seen in the past and that many attorneys have witnessed because it's in open court. And that's one of the most terrifying concepts. Knowing you're in open court, a judge that openly defies judicial temperament, it's spitting in the face of what we consider proper courtroom demeanor, right? A judge's job is to preside over the court and maintain order over the court. If the judge cannot maintain order over themselves, then I think we have a major problem. And so I think that's one of the things you mentioned, the 0 to 100. I actually witnessed one of these. I think it was back when my opponent first stepped on the bench. And I think it was not even a year and a half in, and I went before her. I had actually introduced myself to her at one of our conferences, bar conferences beforehand, and I walked in her room to do a simple prove up. Simple prove up. I believe is actually for my partner at the time too. I went in there to do a simple prove up, and I legitimately watched her. I mean, I walked in, and she was calmly talking. And then the attorney said, "Well, Your Honor, I think we also have to look at this." And then she just went off the rails. And I was really, really surprised about that. So much, in fact, you can ask my partner about this. I took my prove up because it didn't have to be done that day.
Oh gosh.
And I turned and I walked out and I said, "Yeah, I'm not going to feed the judge's fire." And over the course of the next few years practicing in family court, I've seen that continually get worse. I've seen attorneys come out of a courtroom crying. I've seen litigants come out of a courtroom crying, which is a little bit more common. But nonetheless, judges should show their litigants and their litigators an immense amount of respect. That's required. What I vow to do is the same thing. I was taught by a federal judge that I clerked for. His name is Jim Browning in New Mexico. And he's the only conservative judge still sitting on the bench, I think, in New Mexico right now. And he's a federal district judge. And he taught me one very simple thing. He goes, to understand what judicial activism is or not legislating from the bench is, he goes, a judge shall not do unless a judge is motioned to do. If he is not motioned to do, then he will not do. And that's what he told me. And that rang out to me, and that made a lot of sense for me. And the reason being is he said, look, the only exception to a time that a judge should impart their own perspective on something is when they're maintaining the order of their court, the decorum of their court. They need to be able to make sure litigants aren't fighting. They need to make sure that they're actually getting their work done. They need to make sure they're getting through their docket. So setting parameters for the order of their court is something that judges should do on their own. Now, when it comes to an actual litigation, what judges should refrain from doing is,
moralizing.
Well, one of those things is imparting their own personal experiences on other people, because there are many different perspectives in the world, particularly in the US. The beauty of our community and the beauty of our society is that we come from a melting pot. And so there are a lot of perspectives in this world. But more importantly, the purpose of the court is to adjudicate in divorce instances with children and so on and so forth, is to do something in the best interest of the child. Now, my opponent said something in a forum the other day, and I thought was I was a little flabbergasted. She said that the best interest of the child is subjective. And I said, the interest of the child is not subjective. We have, we believe in health, safety, and welfare of the child. Those things should be uncontested. There's no subjectivity there. You don't just look at this. It is an objective standard. It is a standard for a reason. And that's the reason why I look at that and I was like, that didn't make a whole lot of sense coming from a sitting judge. And then she proceeds to talk about how the judges have discretion. And that terrifies me, because when you look at conservative values and you look at values of family, you want to know that the judge has their values well rooted. And if you don't have values well rooted, then you get they make discretionary choices that are not necessarily good or make sense. And I think that's what we've seen in the court. I also vow, the three things that I focus on in my campaign are ethics, morals, and the rule of law.
Mm-hmm.
And we look at that and I say, ethically, I've never been found in violation of any ethics. I've never been on the wrong side of an ethics complaint, period. Okay. Moreover, from an ethical standpoint, I can tell you I've also served with the Unauthorized Practice of Law Committee, the UPLC Subcommittee 7 here in Tarrant County, which prosecutes unethical behavior by non-lawyers and such for the unauthorized practice of law, and suspended lawyers for that matter. And as a result, I've also worked alongside Chief Disciplinary Counsel and so on and so forth. And I can safely say I've always worked alongside them. I've never been the target of them. So I believe that that's crucial. You want to make sure a judge is beyond reproach at all times on their ethics. Okay.
Mm-hmm.
Morals. I differ from my opponent because my opponent believes that the parents need to prove they're fit. I believe she also stated at one point, she said, if CPS, referencing CPS, she said, if CPS fails to prove their burden, the children are returned. If the parents prove that they're fit. No, no, no. If CPS fails to prove their burden, the children are returned, period, in a paragraph. There's no if. Okay. They have a burden to meet. Our law is based largely on presumptions, meaning when you walk into court, you're presumed something until the other side proves their case. And then at that point in time, they shifted the scales to where they're about even. When you shift the presumption, like my opponent has said several times, you can't ever get a real result or a fair result if somebody always in the scales of justice has their hand on the scale. It just doesn't work. And that's been a major problem that we've seen. And then last but not least, we talk about breaking the fourth wall. And that's a reference to movie buffs. I'm a movie buff. I've always enjoyed movies.
Know that term. You're doing it right now, talking to the public, so we appreciate that.
Well, I appreciate you having me on. The fourth wall is when a judge steps beyond their position and starts questioning witnesses, starts pushing litigants to do certain things in their court. That is activism from the bench by definition, but I call it breaking the fourth wall because I believe it's, when they overstep their bounds. When is the last time we see juries of 12 during an active litigation getting to question a witness on the stand, right? And the reason why I use that reference is judges in family court more often than not will act as the fact finders. They're not, very seldom are there juries in family court. And so as the fact finder, I not only have to preside and have order in the court, right? But I also am listening to the facts and I have to make a determination. If I start stepping over my bounds and start asking witnesses questions, start telling lawyers how to do their job, all of that becomes a major problem because now they all understand which side I'm leaning on. My job is to call balls and strikes, sustained, overruled, let them tell the story, collect the facts that they provide to me. I'm not a fact. I don't go out and search for those facts. I don't get to cross-examine a witness. And then from that point, I get to make my decision. And that's how we preserve a proper record. And that's how we preserve proper justice.
George, you want to ask a question?
Not really. I'm enjoying hearing.
It's refreshing to hear.
It's refreshing to hear because so many of us have been taking advantage of court and, like you're saying, legislating from the bench. A lot of us that are pro se are having to go that route because the perversion in the legal field is so great. And it's good to see somebody that actually takes pride in their job and wants to uphold rights. And it's discretion is a huge issue for me. I understand discretion. I understand the word. I've looked it up. I've gone around with it several times. And I do agree that some of the judges do abuse their discretion quite frequently. And so it's a bit of fresh air to hear this judicial candidate, come on, to the people and tell them that they want to restore, parental rights and presumptions. So keep going. I'm enjoying.
Let's jump into interference with child custody, if I can just throw something out there, because last time we were on the phone, I believe you had some theoretical solutions to this pervasive issue of one parent refusing to honor these custody agreements that they both sign, and then that's a big reason these parents have to go back to court. How do you end that cycle, or and put parents on notice that they have to honor that time with the other parent?
So I look at that from two perspectives. Number one is I think what we've had is, and I think George mentioned a perversion of the system, and I, I that resonates with me. It very much resonates with me, and the reason being is we talk about the system, but not the system as it functions today, but the system as it originally was designed. And I think that's very, very crucial for us to look at that. I am a very, very big history buff. I believe that learning history, learning from your history is very important. And if you know where point A is, and you know where point Z is, then you can see how that progression worked. And that's really how you kind of track and see how change happens, right? Because daily change you don't always see, but you can see that progression over a month, maybe 6 months or a year. So I say perversion of the system because first and foremost, if you have a judge that's well-centered and is acting in their capacity properly as a sitting judge in a court, then essentially they're not going to glean any kind of favoritism or bias towards one party or the other. And they're going to call their balls and strikes, and they're going to come to a solution, and they're going to be known for following the law. So if that's the case, and I don't take it outside of the scope of the law, and I keep it that way, then essentially every single person that comes before the court should understand that this judge is going to follow the law. And they're not going to say, oh, well, this is the Wild West. I'm going to go in there, I'm going to say this, and the judge really strongly feels about this. I hear that all the time, and I hear judges say, oh, well, they feel really strongly about this. And sometimes it's true, and sometimes it's not. But it has been true in the court that I've been running against, against the judge I'm running against. My opponent is a very, very heavy favored person towards CPS. She talks about CPS on her own in her forums, unprovoked. So she feels strongly about that. And again, we talk about the perversion of the system. CPS, in its inception, was a noble cause. I don't think anybody can test that. Nobody wants kids to be abused. Nobody wants kids to have broken bones. Nobody wants kids, walking around a house with a bunch of used dirty needles, right? What we want what's best for our kids. Now, when we look at that and we look at CPS, I think that's largely CPS has been laden with scandals over the years, issues with trying to grab for more budget, issues with making arguments that they shouldn't be making, issues with investigating cases they shouldn't be investigating, or not dropping cases they're not supposed to be they're supposed to be dropping. All of that has been an issue with CPS. Now, I'm not at war with CPS, and that's not my objective, but I do believe that a part of the problem comes from the bench. Because if a bench is going to allow those things to happen, then that same bench is probably also, going back to your question, going to allow going to show favoritism, and then one side or the other doesn't feel like they have their fair shake in court. So what do people do? If they go to court and they don't get their decision, and a judge has to interject and make a decision, and they feel like they've been wronged in some way, they're going to have a propensity to want to relitigate. And that's a problem, because every time you go into the tug of war of child custody or a divorce or something like that, everybody talks about a tug of war between the two parents. What a lot of people forget is the children or the child is the rope. And so the objective here is to slow down the amount of litigation. My opponent says she sends people to mediation. And she says she follows up if they don't go to mediation. All I can simply tell you is if you don't know how a court is going to act with the law, then mediation becomes much more difficult to come to a settlement with. Because in mediation, a lot of times the mediators tell you, hey, this judge is likely to do this, or this judge is likely to do that. If a judge is, for lack of a better explanation, kind of off the rails, then the mediator has nothing to be guided by, and the parties have nothing to be guided by. So you really have no idea, a reasonable direction that court might go into. So you get relitigation. And we talk about child custody because that's what happens. People find every little reason to come by. Just yesterday, actually, we found a temporary restraining order signed in a court. I won't go into what it was, but the court that signed it was my opponent. And she signed a TRO without an affidavit.
Mind blowing.
That means some guy walked into her court and said, Judge, I need you to grant this TRO, and without any ands, ifs, or buts, or any gleaning of looking at the thing at a factual statement, she said, "Sure,"
Mm. That
and
happens
walked
too
away with it.
often in Tarrant County, and we've talked before on the phone. Can we talk about what needs to be in an affidavit? How strong does that need to be? Because a TRO or a protective order is so serious, has such serious ramifications for the other parent. What burden needs to be met?
Right. So an affidavit is very simple. It's a statement of fact,
Mm-hmm.
and it's been kind of stretched to reasonable inference. Now, I can tell you what I believe reasonable inference looks like, but let's not go down to that yet. Let's just talk about statement of fact. When we look at statements of fact, they need to be things like, I walked into a room and I saw a gun laying on the ground loaded. Okay, that's a statement of fact. A reasonable inference that may be drawn from that is somebody can grab that gun and start pulling the trigger, right? Another statement of fact would be like, I came in and you know, the child was laying in a pile of their own filth. Okay, that's a statement of fact. But what we have is we have certain instances where people come in and say, I believe that the child is in danger because
Mm-hmm.
they look sad and upset, or when they spoke with mom, they were a little shy. There's a numerous amount. I mean, if that's the case, if a child looks shy, I mean, last night would have been hilarious because my daughter was hiding behind me with our ostrich in the sand kind of scenario in the middle of a forum because
Mm-hmm.
somebody was trying to say hi to her. And no matter what I did, I was like, please say hi to Mr. So and so. They're shy. They're kids. It happens. They have certain reactions that may be learned behaviors or just natural behaviors. Um, but those are things that it's not just an inference, it's a guess at that point. It's a hypothesis, if you want to. And they put those into affidavits and they put them before the court, and the court tries to read the story as a whole. And as a result, as you can imagine, affidavits can be pretty elaborately drafted, let's call it that way. And then courts are inclined to grant it. But in this instance, I just mentioned there was no affidavit. That should be on its face, no. Okay. Um, but there's that. And we talk about the courts about my opponent talks about running an efficient court, a fast court, no backlog. I don't know about you, but when I want to go and argue, when I'm arguing about something as important as my family, I don't want to hear about how efficient or how fast you're going to get me through that court. What I want to know is whether or not the issues are going to get resolved. She's the culmination of do it now versus do it right. And that's going
Mm-hmm.
back to what I'm talking about, the system that's designed. If the judges take their hands off the scale,
Mm-hmm.
then you should naturally have that scale balance to wherever the evidence puts it. And that's just the way it's supposed to be. I want to fully answer your question about the possession and access. You know, I think when we look at possession and access, we see issues where parents disobey certain aspects of the possession and access. And granted, there are probably numerous explanations for different things, like I was there, but I was on the other side of the building, or I was over here and I was inside this McDonald's and he was inside the play place and we didn't see each other. There are always explanations about that. My reasonable interpretation of that in honest misses or things like that, those generally don't come up before the court as often because the parents realize, oh, you were on the other side of the building. And my
Mm-hmm.
response to the parents at that point in time, or my decision to the parents at that point in time is if both parents were there and he was supposed to have the visitation or she was supposed to have visitation, let's do some makeup visitation, potentially look at that, right? There's a ramping up of certain scenarios that you could see
Gotcha.
across the board. But I think there's a reluctance for the court to use the statutes at its disposal to properly make sure the parents adhere to their obligations in the decrees or in the child visitation portions of their orders, right? And there's all sorts of things we could do. We can do make-up possession visitation. We can do findings of fact. So future courts, when they look at it, know that there's been a finding of fact on particular things that may have gone wrong, right? And then they know this is a second, third, or fourth, or eighth offense, whatever it is, right? And then last but not least, there's always the option of contempt. Okay. And contempt is an option relatively of last resort, but that's when parents are flagrant about what they're doing. And there needs to be some sort of remedial measure put in place. And courts, with respect to child support, are extremely, extremely easy to push contempt with. Criminal contempt. They always say it. You could punishable by up to 180 days in jail, court costs, so on and so forth. And that's what criminal contempt is. However, when it comes to issues of, not possession and access and parents not adhering to orders, all of a sudden you see that a lot less. And I can only imagine that the thought process of a person on the bench would be, well, if I put one parent in jail, then obviously the child's not going to see that parent, and there's those other issues. But at the same time, if you're flagrant about what you do, I think the punishment moves along with the scale and the repeat offense. We should look at that the same way. And I'm not saying we should put everybody in jail, but I'm saying is we should evaluate every circumstance based on the facts at hand. And we've seen some of those cases.
In my personal situation, my ex-wife has accumulated several, contempt of court, motions that, they haven't been resolved yet. But generally speaking, it's, first of all, it's very, painful for the parent who loses access to their child. I think we can't underestimate that. And I don't think, anyone here wants to see an overuse of jailing. But I will say that spending one day in jail might change their calculations. And hopefully for, the parent that's not following the law, they'll, that could be a wake up call to them. And I see that being that could be a positive thing for a lot of these parents that don't think they have to honor these agreements. And, maybe they'll change their behavior. And if they do it again, I don't know how that works, from a law perspective, but you kind of put them on notice. There is a consequence. And I do think that is something that should be, there are situations where that is warranted, I would just say.
Well, I agree with that. It's about a range of punishment, right? Mm-hmm. And if you're willing to arbitrarily, as a judge, cut off a range of punishment altogether, then they know this is my worst day in court. Big deal, right? Versus if you say, look, the breadth of punishment is this, and based on the issues that we have, then it makes people understand, hey, look, maybe I should follow these rules, and maybe I shouldn't play squirrely games, But I mean, there's always the saying that you can't legislate behavior, and I firmly do believe that. But I will also say that, there is a certain amount of deterrence that does occur from the manner in which we look at the scope of punishment, contempt, and things of that nature. And I do agree. It should be used sparingly, but it should still be used as an option.
It should be on the table, I should definitely say, because you don't want them to know that this judge will never send a parent to, a weekend in jail. That word will spread pretty quickly, and then you'll have this breakdown of law and order pretty quickly.
I'll say this: in another county I've been before, I've said this before because I know a judge. I've walked up before a judge and I said the judge defers to 50-50. She defaults to 50-50. And it's known among every family practitioner in that county. I practice in multiple counties. I'm not a one-trick pony. I practice both civil and family, primarily family, about 50-60%. But I can tell you, traveling around the many counties, you see this, particularly when you start getting to smaller counties or developing counties. Judges push an agenda, and they're not as held. Their feet aren't as held to the fire because the number of constituents that they serve aren't as diverse in certain instances in more rural areas. And so they feel that, there's a certain amount of small town feel there. And so they don't get opposed as often. But we're in Tarrant County. There's 2+ million people here. Like, that's a lot of constituents that judges have to serve. Right. And so the best way to look at that is the law. Fair.
If I can jump in, 2503, I founded the 2503 page, and we've helped a lot of parents. And one of the statements we hear a lot is that we advocate to make parents felons, and it's not that at all. We just want some sort of accountability. And in my instance, and the reason why I helped start this movement was because I wasn't seeing anything in my family court. My family court my judge would routinely let her off the hook. So this all started with a possession and access filing 7 years ago. I'm still in Harris County Court. I'm still, they found her in contempt, criminal and civil contempt. They gave her 10 years probation. She still violated. They still didn't want to revoke her probation. And now we're here. 7 years later, I finally had final trial in November of this last year. So filing an offense report for interference with child custody, the reason why we went that route was to hold some sort of accountability to that person on the criminal side. If the civil side and the judge wasn't going to uphold the law on the civil side, then that's a dead end. So let's use our other relief that we have, and that's the criminal relief. So one of the things I asked my judge before trial was, well, Judge, which laws are we upholding? Are we upholding just the family code? Are we holding up the code of criminal procedure, the penal code? Because if there's no mechanism of reporting, then how do I bring a violation of this report to prove contempt? Because if law enforcement won't give me the report I need, she quashed my subpoenas to the law officers that took those reports. They gave me incident reports. So there's really no mechanism of reporting on the criminal side through law enforcement. And then if there's no relief on the civil side, I think a lot of these parents, and like you said, a lot of these parents just want to be heard and want the judge to know. And I hate to say that I go into this court and try to be a menace, but at some point, when I go into these courtrooms, I'm trying to find a baseline of that judge. Judge, what dictionary are we using so we can communicate properly? Which codes are we following? Are we following the family code, the penal code, the code of criminal procedure, the government code? And again, it's refreshing to hear somebody that has pride in their job and working for solutions, because a lot of families go into these courts with problems and they don't have solutions right offhand. And if we don't have a true baseline of this judge that we're going before, whether they follow the law or how are the scales, right? Are they even or are they slanted one side? So it's refreshing to hear. And again, when parents go in there saying interference with child custody, it's not to make a parent felon. All they're looking for is some sort of general relief to be heard.
Well, and you're 100% correct there, George. It is about being heard, because you mentioned something about, and we've witnessed this before as practitioners, but you mentioned something about getting police reports or incident reports and things of that nature. I don't know the circumstances in which the evidence was looked at or presented to the court. What I can tell you is I'm sure you've heard it before, but I can't give you legal advice if I'm a judge, right? They say, oh, well, I'm sorry, sir, I can't give you legal advice.
Right.
The interesting concept of that is, and this is the real interesting concept, we've seen judges basically nothing short of coming over the bench and telling litigators what they want to hear, right?
Yeah.
But when you have two pro se's that appear in front of them, they are so reserved. They're like, I can't give you advice. I can't do this. I can't do that. Well, why not use that same? And I'm not advocating for the judge to tell the pro se's what to do, because, the law says very clearly a judge cannot advocate one direction or another. They must first and foremost be impartial. But I will say that same approach is the taking your hands off the scale, so to speak, is to not also go across the bench and try to address the attorneys and in telling them what to do, or saying, this is what I want to hear, counsel, move on to this, right? Because those type of things, I can say certain things like, that's not relevant, because that's a valid objection in court. Objection relevance, you're right, that's not relevant. Move on, counselor. I can do that. But what I can't do is I can't say absent an objection or absent doing something, I can't go in and be like, counsel, this is what all I want to hear. Get out of my court. Because all that tells the litigant is I'm tired of this crap. Get out. And that's not fair. That's not what it's about. And then talking about the police reports and incident reports, I know, because police reports, they come out and they say, well, I can't do it. How many times have we heard? I can't do anything about this. I can just take an incident report, right? Those I understand law enforcement has their position in this, and their job is not to regulate or be the arbiter of a civil situation. But it comes a point where that incident report needs to be looked at, and as long as it's properly admitted in court, it should be looked at. We have our rules of evidence, we have our rule of law, and I go back again. The beautiful part about being a judge, the way I see it is it's relatively simplistic in the sense that the law is my haven. As long as I read the law and I follow the law, and I practice the law, then that is something I should be coming to a solution that everybody else has equal ground of seeing. John Adams once said, "We are a nation of laws, not of men," which means that if I go on there and I put my own perspective on the law, then you're a court of a man at this point. But if I go in there and I read the law and the law doesn't give me discretion, guess what? I shall. If it gives me discretion, then you need to know, and that's where my conservative values come in play into what kind of discretion I'm willing to exercise, right? The level of discretion I'm willing to exercise. And in my approach to it is judges need to remain as hands off as possible. Judge Harris actually here in Tarrant County said something once best. He always would use to give his litigants a kind of, I don't want to call it an admonishment, but he would give them a kind of like, hear me out here for a moment, guys. And he would have them come up and the litigants with their attorneys, and he'd be like, attorneys, I want to speak freely. Is that okay? Because he doesn't want to go past the attorney's advice. And the attorneys would almost always go yes. And then he would be like, he explained to them, like, look, you two have kids, you two have been married, you two have been together, whatever the reason may be, you are looking for the court to make a decision. I want you to understand that the parents are presumed fit. So if you make a decision between the two of you and you can come to that decision, then that is infinitely going to be better than if I, a random person on a bench wearing a robe, is going to sit there and make that decision for you. Because in truth, a judge really doesn't know their litigants from Tom, Dick, Jane, or Harry. And so I have to follow the law. I don't get to get creative, right? I don't get to say, well, I really think it should be this way, so let me use my discretion here and make it this way. No, the law says I have to do something, I have to do something. And that's really the truth of it, right? And so Judge Harris would give a very good, I guess, a pep talk, is a better way to put it. And he'd be like, on your way. It was not part of an adversarial process. It was not part of a very tumultuous, acrimonious process or anything like that. It was just hey, here are the facts. I just want you guys to realize that this is the case. And, this is the only time I'm going to tell you guys, but just understand that. And I don't see any problem wrong with that. And that also helps you keep order, because if the parents come to a resolution on their own, then guess what? They're twice as likely to stay on that resolution because they came up to it together than they would if I made a decision. Then they'd be back in 3 years after a substantial change of circumstances or what they would claim. And we would have to start all over again. So in family law, having a judge that is well-grounded, having a judge that understands they need to keep their hands off, and having a judge that follows the law should in turn promote better options for the litigants to settle, better options so they don't have to relitigate, and better options so, frankly, this doesn't turn into a knockdown, drag-out fight where they pull the kid apart.
George, maybe we'll each ask a final question. Do you want to go first, George, or make anything you want to kind of throw out there?
Yeah, real quick. Some of the patterns that a lot of these advocates and pro se litigants and litigants in family court are asking about lawyers that are intentionally, willfully making statements of fact that they know are untrue, just basically weaponizing their legal skill to remove another parent. If you get elected to judge, how would you combat that? Lawyers that are not following Texas Lawyers Creed or not following the disciplinary rules of professional conduct.
So I'll tell you this. That's a loaded question. I can't really glean what I would do in that situation because it's factually dependent. But I'm going to answer the question like this.
Or just your beliefs. Yeah.
As an attorney, we have witnessed the weaponization of certain things. And I go back again to CPS, right? I've had parents had CPS called on them and then CPS comes bursting in their door, and a lot of people just don't know what their rights are when CPS comes bursting in. They say, I have to talk to your kid. And it's like, can I resist? Can I say no? Can I not let them in? And the answer is yes, you can. You could say, no, I don't want to. Go get a warrant and then come back and chat. Because you know what? If they did find anything wrong, or they already knew something was wrong, it wouldn't be CPS at your door, it'd be the police. So we talk about weaponization of that, weaponization of protective orders, weaponization of TROs. That goes back to what I mentioned early on in this conversation. It's kind of eerie, kind of the 360 here. But we talk about being consistent with the law. And what that means is that if somebody comes in with a protective order, somebody comes in with a temporary restraining order, they need to have all their ducks in a row. That is an ex parte hearing, which means the other side's not there to defend themselves, right? And if being an ex parte hearing, if you're going to come in and ask the judge to do something, you, at the very least, you're not being asked questions. The other side's not combating you on this. You, at the very least, need to have your ducks in a row. And if a party comes in without their ducks in a row, you don't really have a choice but to send them back and say, hey, look, sorry, you haven't met your burden. Okay? Simply saying, judge, can I have this, is not enough. And when we talk about lawyers in particular, I can tell you that, and again, I work with chief disciplinary counsel, so I can just simply say this. If a lawyer decides to suborn perjury, or a lawyer decides to do something that they're not supposed to be doing, then that lawyer should be punished by their ethics. Okay? They should be punished by CDC. They should be punished in accordance with their ethical obligations and the rules and the creed that you mentioned that govern them, right? If I go out and I disclose attorney-client privilege when I'm not supposed to, guess what? I'm in violation of my ethics. I need to be punished for that. Okay? If I go out and I say, well, my client did this and they didn't, or your client did this and they didn't, and I didn't do my what we call is reasonable due diligence, right? We have an affirmative duty of due diligence to our clients. Now, that could be as little as asking them a question, and that can be as much as digging into the circumstances that happened. That's a discretion that the lawyers have. And the problem is and I'm going to step back for a second from where the judges are, but when we talk about judges that don't hold lawyers' feet to the fire, or judges that don't sit there and make sure the burdens are met, and judges that don't sit there and do what they're supposed to be doing, what we call is bad benches create lazy lawyers. If I know I'm going to get away with getting a TRO without doing the necessary work, guess what? I'm just going to walk that sucker through. That's not right. That's why I practice in so many counties. A lot of people ask me, they say, well, you don't practice as much in Tarrant County. Actually, Tarrant County is my primary practice area. My opponent claims that I don't have that many cases that I have attorney of record. But my firm, if you look up me and my partner, I've handled trials for him. He's handled trials for me. I'm pretty sure there's a plethora of them. But I'll just simply say this. I practice in multiple counties, so I can't keep track of every single judge's predisposition towards one part of the law or the other, or their decision-making tree. I don't know them as well, right, as I would the Tarrant County judges. But you know what? My success rate in other counties, I would argue, is just as high as my success rate here in Tarrant County, which is relatively high. And the reason why is because there's no reason for the judge to kick me out or tell me no, or say, because I've done all of the things I'm supposed to do, I've met my burden. And if judges hold every single litigant to the fire as if it was the first time they walked into their court, you would not have favoritism. You would not have issues where you're saying, well, I'm going to give that person the benefit of the doubt, or I'm going to give them the option to do this, or I'm going to give them the, or I believe that they're going to do that and down the road. No, it's you either meet your burden or you don't. You have to meet certain thresholds. The law is construed as a scales of justice. What we call it is under the way we practice law is it's more of a presumption shift, right? You prove your point, okay, the presumption shifts to you to prove your point back, right? And that's what happens. Likewise, we also look at the law from the perspective of, what we call equity. So in that's the balance, if you so to speak. But again, when we look at presumption, burdens have to be met. If burdens aren't met and judges don't hold those burdens true, then you have attorneys that basically go rampant and they don't do what they're supposed to do, or they try to get away with murder, essentially. But it's not, that's why I say bad benches create lazy lawyering. And I don't like that. I hate that. We win the majority of our cases on procedure.
That's really, really well said. I love that slogan. We're going to remember that. There's a lot of, unfortunately, because of the bad judges we have in a lot of our Tarrant County family courts, we do have a lot of lazy attorneys. So we hope that changes soon. One final thought, if I can put it out there, and you can kind of, close out. We appreciate your time, and we want to encourage everyone to go to for360.com, FOR360.com, and follow this attorney, judicial candidate. But I want to kind of just set up, what George and I see, and what parents are dealing with in Tarrant County, Texas, and what you'll kind of be working with, if you're elected, which is that a lot of fit parents in Texas lose access to their children due to family court litigation. Parents who have never abused, neglected, or abandoned their children still will find themselves severed from their biological children, and then so that's the bulk of the parents that our messenger groups and all our networking. There are a lot of these parents out there. So my question to you is, I know you're a constitutionalist, you follow the law, but even within that framework, what can you do as a judge to ensure that the fundamental rights of parents is protected? Because there are going to be a lot of false allegations that will come through the 360th if you're there, and we do not want to see more fit parents lose access to their kids.
So I mentioned presumptions earlier. The law, and what I'm about to say mirrors the law, but the presumption is in favor of the parents. The parents are presumed fit until they prove us otherwise. Plain and simple. That's, my opponent believes that the parents need to prove they're fit. That's an incorrect approach, first of all, but it's also a very jaded approach. And, what a lot of people don't seem to understand is my opponent has pushed for CPS away from a good standing judge in Tarrant County. I think it was in 2000 or something like that. We have our courts broken up into basically special interest, where the clerks distribute the workload depending on the type of law that comes in. If it's a family case, it goes to the family district court, but we're still courts of general jurisdiction. And then we have the civil courts, which are really courts of general jurisdiction, but they handle only civil stuff. They don't really handle any of the family stuff. Simultaneously, we also have criminal courts, and we also have like juvenile criminal courts and such. CPS used to belong in the juvenile criminal courts because it's largely prosecuted by our district attorney. And when being prosecuted by the district attorney, having a judge that's fully aware of all of the ins and outs of juvenile court and the ins and outs of criminal procedures is probably going to be best. My opponent fought after complaint, and I still don't know what the connection of lobbying here is, but fought to have those cases stripped from that judge and brought to family court. And ultimately they have been. And she's the primary judge that oversees those the CPS issues. And so what we see at this point in time is we see somebody basically essentially rubber stamping CPS orders, and we've seen a lot of bad decisions come down the line. I'm not going to critique every single one of them, but I'll just simply say, one bad decision is enough. That shouldn't even happen. And judges can't look at something and be like, I don't have enough time for this. Let's move here. I've never been accused of working too little. As a matter of fact, you're more than welcome to ask my wife. If anything, she'll tell you that I work way too much. I think I'm on the phone from 7 in the morning till about 1 o'clock in the morning. And that's just the way I work. I don't have an off button. She always looks at me. She's like, how do you always look like you have a fresh set of batteries in your system? And I look at it and I go, I don't know. It's just me. And then I run myself ragged, and then I get a good time where I get a good sleep on a weekend or something like that. And then I go back at it. And everybody asked me, they're like, well, you're just energetic. And I said, I don't believe in halving anything. I hold everything. So that's just the way I do it. I do want to touch on something that you guys had mentioned earlier about dealing with just judges' discretion and dealing with the propensity for judges to make decisions on the fly without doing their necessary due diligence, right? Because the judges should conduct their due diligence as well. And my opponent in this instance, I can tell you, and I want to go back and talk to you, the courts determine, particularly the family courts, they determine things like child support. They determine your net income, your gross income. They determine a just and equitable division of your assets. They determine the distribution of your retirement accounts. They go through your entire financial. When you walk into family court, guess what? You turn over your tax returns, don't you?
Mhm.
Your tax returns, your pay stubs. They go through every aspect of your financials. And the reason being is they're trying to make sure there's a just and equitable distribution of your assets. The court also controls $2+ million each year of taxpayer money. I want to let that sink in. $2+ million of taxpayer money each year goes into the budget to maintain that court. My opponent has been bankrupt 3 times since 1999. She's had bankruptcies active through 2016. That's 17 of the last 25 years. It is spanning from a Clinton was in office in 1999, and Obama was in office by the time her last bankruptcy finished. Why is that relevant? I believe that people deserve second chances. I believe there's redemption. I believe that there's salvation, so to speak, that you can find. If you made a mistake, financially speaking, the court should look at that as an isolated incident. But if there's a pattern of that, and there are 3 of the same mistake, look, there's the old saying, right? Fool me once, shame on me. Fool me once, shame on you. Fool me twice, shame on me. What happens when we get to the 3rd time, guys?
Mhm.
You can't have somebody who can't handle their own finances determining $2 million of taxpayer money and how that's spent, and you can't have somebody who can't be fiscally doesn't have that's fiscally bankrupt, basically determining how you should spend your assets and what you should determine in your assets, right? She says she follows the law, but that goes back to her values and where she gets her discretion from. And that terrifies me.
And then she's honoring TROs without an affidavit. I mean, there's shortcuts right there. And that's what I talk about, like perversion of your profession. Because, I was a fireman, and if I cut corners, if I didn't bring the right ladder to ladder the roof, somebody could die. And in this profession, you're dealing with children, you're dealing with people's retirements, with their homes. And if you're skipping out, you're saying you're following the law and you're just pencil whipping things just to move more efficient, and then you have 3 bankruptcies. It obviously, not only do you have a pattern of bankruptcies, but you also have a pattern of taking shortcuts, which is cheating other people. So those are my thoughts on that.
I've always looked at the financials as a respect for your household and your money and your well-being. So I'm fiscally conservative. I have no problem admitting that. I don't spend what I don't have. Even, that's just the way I was brought up. My parents always looked at me and said, look, don't spend what you don't have, and you'll never run out of something or you'll never run over your budget. And I said, that's a fair enough assessment. And then that teaches you how to keep your life in order. And so I've always done that. The scary part about it is, that's without me ever deciding anybody else's financials, and I don't, the law presumes so many things, but just to shed some light, I can't be a trustee. I can't be a receiver. I can't do so many things according to statute. I can't do so many things because I've been bankrupt. If I've been bankrupt in the past, right? You have to understand, if anybody's been bankrupt in the past, they can't act in so many capacities under the law.
Oh, wow.
Yeah, they're barred from doing so. So the judge is the ultimate trustee, if you will. You're entrusting your case, your livelihood, your money, your time, your kids, your family to the decision they're going to make. If they've been bankrupt and it's in accordance with anything like let's say probate law, for example, is a primary example. That is a direct bar to them being, an executor or trustee to a particular estate. Why would we let them do the same thing and preside over a bench when they can't preside over their own finances in their own life?
Mhm.
As you can tell, one of the things that my pet peeves in the world is I do not have any appreciation whatsoever for hypocrisy. So,
Well
I
said.
mean, and we don't have the room for it on the bench, to be honest with you.
Especially, I would say, well, they're all important, but family court, the consequences for these parents and these families, you started off talking about family, right? So, your grandfather, made so many sacrifices, and everything that happened afterward, kind of reverberated, right, throughout, the world and history and all his kids and grandkids. And I wasn't going to mention this, but my grandfather, Jason Choi, passed away yesterday. He was 94 years old. Beautiful life, married to my grandmother his whole life. Beautiful marriage, 3 children, great grandchildren. I have 3 cousins. Anyway, it's amazing when you make the right decisions in life. For your family, how that beauty just um, reverberates. But to the point of family courts, those decisions these judges make affect the most fundamental part of our society, which is the family units. Even when that family unit breaks up, that bond between the parents and the children is so critical. So yes, we don't have room for hypocrisy and judicial misconduct, and there's no room for that when you deal with families.
That's 100% correct, right? Because look, if we expect anybody, if judges are supposed to be beyond reproach and judges are supposed to be an example, which is, you know, my parents told me, and then they said to me, they said, look, just remember, you'll always be under uh, a scrutinous eye, right? They said, when you're on the bench, you always be under a scrutinous eye. And I said, I understand that. And they said, we don't see any issue with it because you've never, I mean, I'm probably the most boring person when it comes to this stuff, but I don't drink. I don't smoke. I don't do anything like that. Literally, I think that's where I find my energy. I just have to devote everything else to other things. I believe in work-life balance. I believe, in that concept. Although my wife would disagree on the work-life balance aspect of it, I try to incorporate my family and my kids in every aspect of my time. They have been on the road with me for every aspect of this campaign. They have supported me through every aspect of this campaign. I do want to tell them that in the most simplest sense, I'm extremely grateful, and I don't think I'm worthy of their admiration or I'm worthy of their support in certain instances because they have sacrificed just as much, and my parents as well. I truly do mean this, and I believe in the family unit. And coming from a family that when I was a child almost split up, I'm very happy they stayed together. But a lot of that had to do with understanding the kids. And I'll tell you that they've taught me everything I know. My father, in particular, has welded our values to my soul. I mean, that's just the way, if you've ever seen an Asian parent and family, what the father does is that. And I try to do the same thing to my kids. I try to explain to them, I'm like, look, mom is here to be kind and to be nice and to teach you. I'm here to make sure you remember.
Mhm.
And that's the way I look at it too. So to answer your question about visitation access, I do believe that the presence and the default should be both parents should be involved in that child's life. They have to be. They have to be. And we've seen the deterioration of the family unit, and we've seen the deterioration of the system foster more of the deterioration of the family unit. And we just can't keep seeing that.
All right. Well, on the George, you want to close out? I want to. He's a busy guy. He's got to run for office, so I don't want to take up his whole morning. So we
Oh, yeah.
appreciate.
Hey, we appreciate you. We support you. I like everything I heard. I'm kind of big on accountability and transparency. You totally came out and showed out and told us what we can expect. If you're elected, I can't vote for you because I'm down here in San Antonio. But those that are watching in North Texas parents that are part of interference with child custody or following Ed Brown, please consider this. Don't worry if he's not your side of the aisle, if he's red or blue. What I like to tell people is you should make an informed decision based. You should know your candidate, and this is kind of why we're doing some of this podcasting for you people. Is so if y'all are up in North Texas and you're looking for a candidate to vote for, he's the man we need in office.
No, I very much appreciate that, and I also appreciate the time that you guys have. I mean, doing these type of things isn't easy. You know, all I have to say is I'm extremely grateful. Thank you so much.
Anytime.
I hope it wasn't too painful. We tried to.
Well, I'll tell you this much, and
Yeah.
I invite this to everybody that I talk to. I said, look, when I'm on the bench, if you've ever wanted to just have lunch and ask me how things are going, or you want to come in and watch my court, I invite it. It's something that I think judges shouldn't shy away from. If you feel the need to hold a judge accountable, I think that's one of the things you can do. You can go in there and see how they conduct themselves. And if they do so in such a way that is derelict of their duty as a judge and their oath, then it's your right to be able to put that news out there.
Definitely, yeah. I encourage folks to go watch Judges. I'll give credit to Judges. I've seen some really good trials, and I've seen some really horrific scenes that shocked me. But you'll get an honest interpretation, and I think it's kind of our civic duty to spend time sitting in courtrooms and just observe. That's our public forum, and those are folks who work for us, and maybe that'll be you sooner than later. All right. Well,
I appreciate that. Thank you so much for your time, guys. And like I said, I wish you guys the best. And
good luck with the
hopefully
campaign.
We'll talk soon. Huh?
All right. Thank you.
Good.
Thank you again.
All right. Y'all have a good one.
Thank you.